turn to our first witness panel. I want to welcome Congresswoman Marcia Fudge, Congressman Luis Gutierrez, and Congressman Louie Gohmert. Thank you for being here. You'll each have 5 minutes to make a statement, and if you have a written statement, we'll include it in the record. The first person to speak is Congresswoman Marcia Fudge. She represents the 11th Congressional District of Ohio, currently serving her third term. In 2012, Congresswoman Fudge was unanimously elected by her colleagues and serves as the chair of the Congressional Black Caucus in the 113th Congress, member of the House Committee on Agriculture, where she's ranking member on the Subcommittee on Department Operations Oversight and the Committee on Education and Workforce. Congressman Fudge, thank you for being here today, and please proceed.
Thank you very much, and good morning. Thank you, Chairman Durbin and Ranking Member Cruz. I would just say that it is interesting that the ranking member believes in state rights when it favors his position. You cannot have it both ways. Either the Justice Department is over prosecuting persons who buy guns illegally in states, and if they are, then they should also be over stand your ground laws. I'd like to focus on 3 issues that have serious implications to the public safety of our country: stand your ground laws, concealed carry laws, and racial profiling. On February 26, 2012, a young man lost his life, in my opinion, due to racial profiling. Earlier this year, Trayvon Martin's killer, George Zimmerman, escaped the grip of justice because of Florida's concealed carry and stand your ground laws. The 3 issues that I highlight today all manifest themselves in the senseless death of 2 many young men, including Jordan Davis, who was killed for playing music too loud in his car. Trayvon and Jordan didn't ask to be martyrs. The American legal system made them martyrs. I thank Sabrina Fulton and Lucia McBath for being here today. Your strength is inspiring. I fully understand the right to defend oneself from violence as an established principle in our legal system. However, stand your ground laws eliminate all responsibility to retreat and peacefully end an incident. These laws permit and, quite frankly, encourage individuals to use deadly force even in situations where lesser or no physical force would be appropriate. At the urging of ALEC and NRA, the first stand your ground laws was enacted in Florida in 2005. Since then, 22 other states have enacted similar laws. The NRA and ALEC actively lobbied states to lower the personal liability and social responsibility for those who carry firearms. Ultimately, this effort fosters a Wild West environment in our communities where individuals play the role of judge, jury, and executioner. In my home state of Ohio, House Bill 203 would expand the concealed carry law to permit the use of lethal force wherever an individual is legally permitted to be, while removing the duty to retreat. This change to current law would bring Ohio in line with other stand-your-ground states. Proponents of stand-your-ground laws often allege that these laws deter crime. However, the opposite is true. According to a study by the University of Texas A&M, states with stand-your-ground laws have seen an 8% increase in homicides. The enforcement of stand-your-ground laws too often rely on the decisions of those with cultural biases on whether a person's life is in danger. Not surprisingly, these decisions have had a disparate impact on African Americans. The Urban Institute's Justice Policy Center found that in stand-your-ground states, 35.9% of shootings involving a white shooter and a black victim are found to be justified. Only 3.4% of cases involving a black shooter and a white victim are considered justifiable self-defense. These numbers should make all of us uncomfortable, Mr. Chairman. Racial profiling continues to make communities of innocent individuals fear a system designed to protect them. Under New York's unconstitutional stop and frisk policy, more than 90% of all those stopped by police were either black or Latino, even though these groups only make up 52% of the city's population. Given the underlying taint of racial profiling in both our culture and criminal justice system, it is troubling to see more states trend towards enacting stand-your-ground laws. The Center for American Progress's report, License to Kill, shows the intersection between stand-your-ground laws and weak state gun permitting laws. While every state has concealed carry laws, they differ on eligibility requirements. There must be a strong, uniform standard to allow an individual to carry a deadly weapon. Weak concealed carry standards combined with stand your ground laws and racial profiling are a recipe for danger. We in Congress must continue to work with the Department of Justice to monitor and evaluate the impact of these three issues. And until these unjust and inherently biased laws are repealed, we have a responsibility to advocate and to educate. Our work will not be complete until we ensure that no one has to live with the fear of death based on his race or his age, or a death that is justified under stand your ground laws. I look forward to the day when every American can live knowing that the arc of justice bends toward fair and unbiased laws. I yield back.
Thank you, Congresswoman. Next up is my colleague, Congressman Luis Gutierrez from Illinois. He's now in his 11th term representing the Illinois 4th Congressional District, chair of the Congressional Hispanic Caucus Immigration Task Force, and leader in an effort to pursue comprehensive immigration reform. In addition, he serves on the House Judiciary Committee and the House Permanent Select Committee on Intelligence. Congressman Gutierrez, thank you for joining us today.
Thank you, Chairman Durbin and Ranking Member Cruz. Thank you for the opportunity to testify on this extremely important issue. I extend my condolences to the families who lost loved ones. Ms. Fulton and Ms. McBath, I am deeply sorry for your loss, and I appreciate your presence here today. And as one dad to another, I say to Mr. Martin that I too feel your pain. And thank you for being here. As a parent, I was shocked by the death of Trayvon Martin and the fact that no one was even arrested after it happened. An unarmed teenager was pursued by an armed adult in the neighborhood where he was staying, shot to death, and nobody was convicted of a crime. I respect the verdict and the judicial process, but I have deep concerns about the expansion of self-defense laws, the proliferation of guns, the weakening of gun laws, and how this affects public safety. The case of Trayvon Martin, like Sandy Hook massacre, should have sparked a response from our nation's lawmakers. Mr. Chairman, I too requested hearings on this matter as a member of the House Judiciary Committee, but received no response from the chairman. Examining the stand your ground laws and whether they make our community safer or less safe is critically important as part of a larger examination of the impact of gun violence on America. Sadly, we lose a classroom full of kids every day to gun violence across this country, and there have been no hearings in the House. So, Senator Durbin, I applaud you for your leadership and for holding this hearing. The fundamental problem is Americans are so afraid of other Americans that they feel they must arm themselves. The gun lobby is pursuing to reshape our laws to make this practice more socially and legally acceptable. Special interests are relaxing our laws, resulting in an escalation of the deadliness of these confrontations. I have never believed that allowing more guns will mean less gun violence. We must confront the deadly combination of rampant fear of one another and easily available guns. We must examine shoot first or stand your ground laws in this context. In 22 states, stand your ground laws expand the use of deadly force outside your home to any place you have a legal right to be. We seem to have made a decision that it is acceptable to use a weapon on another human, but have failed to have a serious conversation about under what circumstances. Under shoot-first laws, a person is presumed to have a reasonable fear of death that justifies the use of deadly force in many places. In some states, there is also immunity from civil liability, criminal prosecution, and even arrest. I grew up in Chicago in a very different era. When scuffles broke out, it was up to us to protect ourselves. But no one had clocks and no one had AR-15s back then. New concealed carry laws and shoot-first laws are a recipe for more dead sons and daughters. The GAO estimated last year that approximately 8 million permits for concealed weapons were issued in the U.S. Illinois has become the 50th state to allow concealed weapons. As a father and a grandfather of a 10-year-old, I strongly oppose proposals to allow national reciprocity for concealed weapon laws issued by states with fewer safeguards than those in my own state of Illinois, where my grandson resides. For the safety of all of our loved ones, we must take every reasonable precaution to ensure that individuals who are violent or a public threat do not have easy access to weapons. That's why I've introduced legislation this year to ban cheap, junk guns, used disproportionately in the commission of crimes. But legislation is only part of the solution. In Chicago, we continue to develop strategies to reduce violence and target at-risk youth. Teaching our kids how to resolve conflicts without pulling a trigger makes more sense. Instead, the gun lobby is pursuing shoot-first laws and claiming they deter crime. Truth is, these laws increase murder rates. Researchers at Texas A&M found shoot-first states have an 8% increase in homicides relative to other states, translating to 600 additional parents, children, and friends killed every year. Moreover, shoot-first laws exacerbate the mistrust of the police among minority communities. There is a widespread feeling in poor and working-class communities that the police are there to protect people from them, not to protect them from other people. That trust further deteriorates under shoot-first laws when communities question whether racial stereotypes or biases will enter into a subjective determination that someone had a reasonable fear. When we allow people to take the law into their own hands, when police hesitate to make an arrest when a young person of color is killed, or if we turn cops into immigration agents, like the House Judiciary Committee's proposal on the SAFE Act, public safety suffers. Engaging in this dialogue is a critical first step. Congress should guide this discussion, carefully monitor the application of these laws, and watch out for racial disparities. I want to thank Senator Durbin for his leadership and for his service to Illinois and for the opportunity. And last, Mr. Chairman, I would ask, and Stand Your Ground in Illinois, an editorial in the Chicago Sun-Times, be entered into the record.
Without exception, will be added to your, or without objection, I should say, will be added to your testimony. Thank you, Congressman Gutierrez. Our next witness is Congressman Louis Gohmert. He represents the 1st Congressional District of Texas. He's in his 5th term in the House. He's a member of the House Judiciary Committee, where he serves as Vice Chair on the Subcommittee on Crime, Terrorism, and Homeland Security. He's also a member of the Committee on Natural Resources. Congressman Gohmert, please proceed.
Thank you, Chairman Durbin, Ranking Member Cruz, members of the committee. I'm before you as someone who has a heavy heart for every victim of crime, especially violent crime. I humbly come before you today as someone who has been involved in successfully prosecuting murder. I've defended a man who happened to be African American of murder, in which he was acquitted using self-defense, having killed a naked man. I've successfully appealed appropriately and have gotten a capital murder conviction reversed in which the defendant happened to be African American. I've presided over many murder trials as a judge, as a Chief Justice. I've reviewed murder trials on appeal. So I'm somewhat familiar with the process involved with murder and assaultive trials. Though I've won an award for a law review article I wrote, I've won Baylor Law School's moot court competition, won Best Brief Award along with others. Perhaps the highest commendation I've ever had came from now Senator Ed Markey, who after a House hearing approached me and said he wanted to pay me a compliment, that if he were ever arrested, he wanted me to defend him. And he said that was a compliment. I took it as such. Now, regarding the issue of self-defense, as my friend Senator Cruz pointed out, it was in 1895, Beard versus United States. The court said, Justice Harlan, the person was not obliged to retreat nor to consider whether he could safely retreat, but was entitled to stand his ground. This concept's been around for a long time. Some feel that there should be a duty to retreat before deadly force can be utilized for self-protection, but some have found that without a duty to retreat, there are fewer assaultive crimes with due deference to Texas A&M. In most places, a deadly weapon does not necessarily have to be present if the victim is in reasonable fear of death or serious bodily harm, worded in different ways. That idea of being able to stand one's ground without first retreating has been combined as part of the law of self-defense in at least 22 states. It might also be noted that these 22 are not necessarily states in which runaway murder rates abound, as they do in some locations where the self-defense is more limited or where gun control laws are most extreme, as in Washington, D.C. or Chicago, Illinois. Florida and other states have used their right to be the source of police powers, which was secured to them under the 10th Amendment of the Constitution, because those powers were not delegated to the federal government and were therefore reserved to the states and the people. That is why states have the right to have their own penal codes, to enact their own laws of self-defense, which laws get tweaked from time to time as necessary. In some states, the doctrine of protecting one's home affords more protection to the homeowner than in other states. In some states, one may stand his ground without retreating wherever he is lawfully located. However, unless the Uniform Code of Military Justice or other federal nexus is clearly present, all of this is up to the state legislatures to make these determinations as they see fit for their citizens. Without a federal nexus, such laws are up to the individual states. The idea that states are less intelligent or less able to discern their citizens' needs is a mistake of federal proportions. Only a Congress that has authorized the spending of over 150% more than it brings in would have the nerve to tell state governments that balance their budget every year that the state does not know how to properly govern their people. With only a few exceptions, most states are doing quite well with legislating in the area of criminal law without our interference. It's only the federal government that has an estimated 5,000 or so criminal laws that have over-criminalized this country. Hopefully, when I'm here again for a hearing, we can fervently work toward eliminating or correcting the thousands of federal laws that have sometimes put people behind bars for things that most Americans have no clue would be against the criminal law. So, Senators, I humbly implore you, let's leave state criminal law to the consideration of the state legislatures, though we in Congress would probably be well served to take advice from the states that are still sovereign. Thank you.
Thank you, Congressman Gohmert. And I want to thank your colleagues, Congressman Gutierrez and Congresswoman Fudge, for their testimony as well. We appreciate your being here today, and we're going to proceed to the second panel. As you depart, thank you again.
I'm going to tell that Mark. He's ready to do some jail time. I should have fucking accused the front on Lindsay to defend me. I'm not going to go down either road. I know you're safe on the first door. I won't do it again.
I'm sorry, if I can ask you all to please stand. It's customary to administer the oath before this committee. If you would please raise your right hand.